In this video, we are going to talk about doctrine of Pith in substance, which is a significant doctrine to decide the disputes and conflicts between the different legislations, where the laws are made by the on any subject by the union legislature or the state legislature, and that dispute, whenever deciding the dispute, this doctrine has been used to decide the conflict between the laws. So we are going to discuss the doctrine in detail. Now, understanding the meaning of Pith in substance. So, Pith in substance collectively means that the very essence and significance of something. So in simple words, that meaning the true nature and the intrinsic character of subject matter in question. So now you know the Pith in substance means the very essence and significance, what it suggests, what is the character or what is the true character of that thing in question is what Pith in substance of that thing is. The origin of doctrine is from the Canadian Constitution, and this was the judgment Cushing versus Dupuy in Canada. And later, after this judgment, this doctrine became the part of the Constitution there in the Constitution of 1867 in Canada, and then it was brought into the Indian context in Indian laws, where this doctrine is used to decide the conflicts between different laws made by different legislatures. So here in Prafull Kumar Mukherjee versus Bank of Commerce, AIR 1947, it was a judgment of Bombay High Court where this doctrine was first applied and used in constitution, used to decide the conflict in laws there in the constitutions. So as you know that there is a 7th schedule under the constitution where the union, state and concurrent list is provided, and whenever the law is drafted and passed by the whether it's state legislature or union legislature, the parliament, those laws are passed on some subjects provided there in the list there, and if that subject matter, that law made on some subject matter transgress or encroach the subject matter of other list. So for example, a law is made by the legislature, the parliament, and then encroaches the subject matter in state list on which the state has power to draft the law, make the law and then pass it. There the dispute arises that this jurisdiction to make the law on that subject is with the state. So the challenge comes, and when the challenge is there, there are judgments, and this principle says that when in Pith and substance, that law is not actually encroaching, but it is incidentally touching that subject. So there it is not the encroachment, but it is just incidentally touching the subject of another list. So in those cases, the laws are always held to be valid and not void because of the encroachment by the legislature on the subjects of other lists. So here this is how this doctrine has been used in India, but we will see the applicability, what is the object, what are the provisions where we deal with, we apply this doctrine, and how the courts have, the Supreme Court and different high courts have seen it, its importance, its applicability, its how this has been applied in different cases, and we also see the illustrations. Now object of the doctrine is to, and the courts take the help of the doctrine by applying the doctrine of Pith and substance to test the true nature of the legislation. So whenever there is a challenge and the challenge is against against another legislature, or even not only another legislature, any individual can file any petition against any legislature, a law passed by the legislature, saying that the actual jurisdiction to pass law on that subject is with another legislature, and there the court see that what is the true nature of the legislation. If the court finds that the law passed by the legislature is actually passed under some subject matter, under its power on some subject matter which is under its own domain, then even if it is indirectly touching something there in another list of another legislature, for example the parliament, and a state making the law and it's incidentally touching the subject matter under the domain and powers of the parliament, then it is not invalid. And to test that whether the encroachment is there or not, this doctrine is applied in has been applied in different cases there, and to see that whether there is such direct encroachment, or whether the state or any legislature has tried to make a law by encroaching another subject matter, and taking charge of that another legislature, which is not allowed as per the article 246 there in the constitution. We are going to discuss the same also. So this is how the courts check that whether the encroachment is there, whether it is just the incidental encroachment, and whenever it is incidental, the law is not invalid, it is always valid. So to test the true nature of the legislation is the core and the very the use of this doctrine, that courts see what is the object, what are the provisions, and there the courts, whenever it is incidental touch by the legislature on another's subject matters, then this is a valid law, not invalid. But whenever there is a direct encroachment, the subject matter does not anywhere comes under the domain of the legislature passing the law, then it is always a invalid law, as it is not constitutionally allowed to do the same. So the principle applies when the enactment falls within the powers conferred by the constitution upon the legislature and does not become invalid merely because it incidentally touches upon the domain of another legislature. So you got the same. I already discussed that whenever it is incidentally touching on subject matter of any other list, the legislation is not invalid, and this is the core of the doctrine, that the courts see that what is the true nature of the law, and find out that somewhere if it is encroaching some subject matter, that is incidental only. Now we see the example that a state law regulating educational institutions may incidentally touch upon subjects in concurrent list or union list if the primary object of the law is to enhance the educational standards falling under the state list. This is a subject matter of state list, but the law may still be valid even if it overlaps with the union list subjects like education or universities. So education and universities comes under the list, the union list, and the law on regulating educational institutions which are with the state powers there, then if it is law made on that subject and it is somewhere touching, obviously if the welfare of the educational institutions are dealt somewhere, and somewhere obviously they are touching subjects like education or universities, obviously it would somewhere, then the courts will see that what is the object of that law, what is the true nature of that law, what that law is trying to do is what the courts will see. And whenever courts find out that actually the law is actually made for the universities regulation, and it is somewhere touching some education thing or universities thing, which is not the actual object of the law, that they are not actually directly dealing with universities or education, they are just regulating the educational institutions, the law is for that only, and it is somewhere to make the law in its true spirit, it is touching education and universities. So whenever this is the scenario, then the law is valid, it is not invalid, because it is using, it is dealing with somewhere dealing with the education or the universities. So this example illustrates it very well, that whenever this is the intention of the law, the true object of the law is to make to regulate something on the domain of the legislature, and the legislature passes the legislation on that thing, and it is somewhere touching some subjects in another's domain, that will not per se make the whole legislation invalid. So this is what the object and the meaning, and you can say the overall understanding of the doctrine, that what it really does. We take some more illustrations, like a state law aimed at regulating the sale of agricultural products may incidentally affect trade practices, which is subject under the union list. The court would examine the law's primary purpose and find that it is valid under the state list despite the incidental encroachment on union matters. So you see, the trade is a subject under the union list. So state cannot pass any law on that subject, but if it is regulating sale of agricultural products, which is under the powers of the state legislature, state list. So even if that law passed on that subject is somewhere indirectly affecting some trade things, then it is not, the law is not invalid just because it is incidentally touching something, unintentionally dealing with some matters which may somewhere encroach the subject matter there in the union list. Again the same thing. And another example, in a situation where a law purportedly dealing with public health also impacts trade regulations, the court would analyze the law's overall intent and effect. If the primary focus is on public health, the law would be considered valid under the relevant state list entry despite its incidental effects on trade. So I think that the thing is really clear, that whenever the incidental touch on another's domain is there and the power is there, then definitely it is not a invalid law, because the purpose and object of the law is not to do that. It is just incidentally has happened that the legislation somewhere uses those things which may be in the powers of another legislature. Here's this judgment, MS Girnar Traders versus State of Maharashtra and others, 2011 3 SEC 1. So Supreme Court observed that the doctrine of Pith in substance can be applied to examine the validity or otherwise of a legislation for want of legislative competence, as well as where two legislations are embodied together for achieving the purpose of principal act. So you see, whenever there are parallel laws, even if there is a existing law on something and another law has been passed by another legislature, some different legislature, then in that case also the court will see what is the true nature of the law, object of the law, whether it is actually encroaching or in conflict with the earlier law passed there by another legislature who is the competent legislature, has the authority to do so. In those cases also the doctrine can be used. Further, in Union of India and others versus Shah Govardhan L. Kabra Teachers 2002, Supreme Court held that in order to examine the true character of the enactment, the entire act, its object and scope is required to be gone into. The question of invasion into the territory of another legislation is to be determined not by degree but by substance. The pith and substance has to be applied not only in cases of conflict between the powers of two legislatures, but also in any case where the question arises whether a legislation is covered by particular legislative field over which the power is purported to be exercised. In other words, what is of paramount consideration is that the substance of the legislation should be examined to arrive at a correct analysis, or in examining the validity of law where two legislations are in conflict or alleged to be repugnant. So here again on the same thing, that there is a conflict between the legislations passed by different legislators, there this doctrine is to be applied by the courts and to see the true nature, the object, the purpose of the law, and what is the field, what is the subject matter there on which the law is passed, and whether it comes under the domain of the legislature or not. For example, you can say that if the law has been made on some subject, for example, student, and there is a law on universities or educational institutions, then in both of these scenarios the law may somewhere be conflicting, because they are dealing with the students which are obviously going to study in educational institutions, and educational institutions definitely are inviting giving admissions to students. So there may be a conflict on two laws, but they are the subject matters fall under the domain of different legislatures, but the law may somewhere be conflicting on some things. So here the courts will find out that whose competence is what, and what can be the extent of the boundaries there on which the laws should be constitutionally be passed, and to see that this doctrine will be applied, and the courts will see the object, the purpose of the law, a very true nature, the essence of the law, and find out whether the law is valid or not. Is there the conflict actually present there or not. So I hope you understand. Again, in E.V. Chinaya versus State of Andhra and others, I forgot to mention the citation. I hope you will find out. So one of the proven methods of examining the legislative competence of an enactment is by the application of doctrine of pith and substance. The doctrine is applied when the legislative competence of a legislature with regard to particular enactment is challenged with reference to the entries in various lists, and there is a challenge to the legislative competence. The court will try to ascertain the pith and substance of the enactment on a scrutiny of the act in question. Again the same thing, and every judgment talks about the same thing, because the doctrine would always be the same, but it has to be applied where there is a conflict between the entries between the legislatures, and the use of this doctrine, the question will always be decided, always be clear that what is the truth behind the challenge. Is the dispute is there, and any real dispute is there or not? The doctrine will automatically speak of itself whenever the nature of the law is being seen and observed by the courts, that what are the contents of the law, what is the provisions there, and what it tries to achieve. Then this will become definitely clear that the encroachment is direct or indirect. So now we see the general provisions there, how this law, the doctrine is applied, because without understanding the general provisions, the doctrine cannot be understood. So you see the part 11 of the constitution, and there are relations between union and states. That there is a chapter, legislative relations. And here in this chapter, these two articles 245, 246 are relevant to the context we are right now studying. So 245 says extent of laws made by the parliament and the state legislature. Sub-article 1 says, subject to the provisions of this constitution, parliament may make laws for the whole or any part of the territory of India, and the legislature of a state may make laws for the whole or any part of the state. Is that clear? That the subject to the provisions of the constitution, the parliament can make laws for the whole of the territory of India, and legislature of a state can pass the laws which will have an effect to the whole of the state, the territory of the state. Subarticle 2 says no law made by the parliament shall be deemed to be invalid on the ground that it would have extraterritorial operation. So subarticle 2 makes it clear that even if obviously the union, the parliament shall make a law, pass the laws which shall have effect, shall have extraterritorial effect, and that does not affect the validity of the law. It will always be valid even if it is having the extraterritorial effect. Then comes Article 246, subject matter of laws made by the Parliament and by the state legislature. So this is very important because it talks about the different list there in the 7th schedule. So sub-article 1 says that notwithstanding anything in clause 2 and 3, Parliament has exclusive power to make laws with respect to the matters enumerated in list 1 of the 7th schedule, which is the union list. So under the union list, the subjects are provided, and on those subjects only the Parliament has power to make the laws. So if the state legislature passes that any law which is actually encroaching or on one of the subjects matters there in the union list, this is directly an invalid law has been passed by the state. For example, I would give you an example there. In Chhattisgarh, there is a Rent Control Act in Chhattisgarh, and in that act, the legislature has given this provided this provision that on orders passed by the appellate tribunal there in the state, High Court would not have the power to hear the appeals against orders passed by the tribunal. Directly, Supreme Court shall have this power to hear the appeals and the challenges against the orders passed by the tribunal. So this was held to be unconstitutional because the legislature didn't have a power to control the jurisdiction of the Supreme Court, which that is the subject matter completely under the domain of Parliament to decide. So even the curtailing the rights of the Supreme Court, the state cannot do such thing. Only Parliament can do so, because that law controlling the jurisdiction of the Supreme Court is with the Parliament only, right? So I hope you understood. And then sub-article 2 says that notwithstanding anything in clause 3, Parliament and subject to clause 1, the legislature of any state also have power to make laws with respect to any of the matters enumerated in list 3 of the 7th schedule, which is a concurrent list. So in concurrent list, both the Parliament and the state can make the laws, both can make the laws on the subjects provided there, but there is a condition, and that condition is there under Article 254. So let's see Article 254 for a moment. Here Article 254 provides inconsistency between laws made by the Parliament and laws made by the legislature of a state. So sub-article 1 says that if any provision of law made by the legislature of a state is repugnant to any provisions of law made by the Parliament, which Parliament is competent to enact, or to any provision of an existing law with respect to one of the matters enumerated in concurrent list, then subject to the provisions of subsection clause 2, the law made by the Parliament, whether passed before or after the law made by the legislature of state, or as the case may be, the existing law shall prevail, and the law made by the legislature of the state to that extent of the extent of repugnancy be void. So here it has been made clear that even though both state and the Parliament can pass law on subject matters provided in concurrent list, even then if the law has been made by the passed by the Parliament, the law passed by the state legislature, whether before the law of the passed by the Parliament or afterwards, in both scenarios, the law passed by the state shall become inoperative. Shall be void. It's not inoperative. It is the void shall be void, and in that case, the law passed by the Parliament shall prevail. The law passed by the state legislature shall be void. So even if both can make the law, when there are law on the same subject matter of the Parliament and the state both, the law passed by the Parliament shall prevail, right? So this is clause 1. Then clause 2 says, where a law made by the legislature of a state with respect to one of the matters enumerated in concurrent list contains any provision repugnant to the provisions of an earlier laws made by the Parliament, or an existing law with respect to that matter, then the law so made by the legislature of such state shall, if it has been reserved for the consideration of the President and has received the assent, and in state, that law shall prevail. So whenever there is a repugnancy in laws made by the state and it has been approved by the President, even if there is a repugnancy, even then that law shall prevail. The law passed by the state shall prevail if it has been approved by the President of India. So is it clear? But proviso says that even if even the clause 2 says that law shall prevail if it is approved by the President, but if the Parliament subsequently changes, make the amendments in that law, then the law made by the Parliament after the change shall prevail. So here I hope this provision has been very clear to you, that both can make the law on concurrent list, the state and the Parliament, but there are certain conditions when which law shall prevail, which law shall be void. So it is always the Parliament which has the power to override, have overriding effect on the laws passed by the state whenever it is on the concurrent list. So it is clear that the doctrine applies also on the subject matters falling under the concurrent list, right? So for example, if a state law on labor welfare conflict is in conflict with the central law on labor, the court may analyze the pith and substance to ascertain which law should prevail, right? So even in cases where the two laws on the concurrent list is there, but there is a conflict, and that conflict, to decide that conflict, pith and substance shall be applied to determine the true nature of the law, what are the provisions and under which subject matter they fall, whether what is the right subject matter of some law. If some law has been is disputed that it has been passed under the trade subject matter in union list, but actually it is not in trade, it is on business or on sale or something. So this, how it will be decided to maintain the see the pots should be sustainable. It should not always be, the laws should not always be invalid because it is somewhere indirectly touching some other subject matter not in the domain of some legislature. So for deciding that also, this doctrine is applied also on subject matters which are in concurrent list. And here it subsection 3 was there in 246, we didn't discuss, and in this sub-article it is provided that the state shall have power to make the laws under state lists. So 246 to 54 are very important articles to be dealt with whenever talking about this doctrine. These provisions should also be discussed here. Sub-article 4 also is there, and it says that the parliament has power to make laws with respect to any matter for any part of the territory of India not included in state, notwithstanding such matter is a matter enumerated in the state list. So it says that the parliament shall always have power to make laws with respect to any matter, any territory which is not part of any state there in the country. So if the territory is not part of any state, then in those territory, with regard to those territories, the parliament has power to make laws, even if that the subject matter on which the parliament is making the law falls under the list, the state list. So this is to be made clear that in cases where the territory is not under the control of any of the states, then even if the laws passed by the parliament comes under the state list, those laws shall always be valid. So what is the feature of the doctrine? It says that the doctrine plays a big role in protecting the feature of federalism. The rights of the state legislatures to pass the laws should always be protected, and that is how the federal structure, the federal feature of the constitution can be sustained. And there, whenever there is the unnecessary dispute over the laws passed by the state legislatures, is there that the law comes under, the subject matter comes under the domain of the union, because it is very obvious that there are so many matters, the subject matters under the different list, which may be similar, they may be synonymous to each other, but the object and the nature of laws are always different. Their true object is very different. So they are to decide the same, that whether it is a encroachment or not, the courts would see the doctrine, apply the doctrine, and that doctrine plays a role also in protecting the federal feature of the constitution, where the different legislatures have their independent and their rights are protected to pass the laws on on things which are under their domain. So this doctrine plays a role there in protecting the federal structure of the nation. Second says the harmonious distribution of power. So whenever there is a conflict between the laws passed by the different legislatures, there is a courts try to harmonize the powers, the distribution of power, and this doctrine is the tool how the courts do the same. And definitely whenever there is a abuse of power, this doctrine plays a role in preventing the abuse of the power by especially by the parliament. The laws made by the states are always under challenge, would always be under challenge, that this is not under its domain. So if it is very unnecessary, the doctrine comes into play, and this prevents the abuse of the power. So I hope you understood the generality of Pith in substance, and this is the conclusion. You can read it. And so in conclusion, it is a crucial tool in Indian judiciary, that legislative enactments are not invalidated because there is an incidental overlap, and the courts try to see the true character and objectives of the legislations, and upholds its validity if it is the incidental encroachment. The doctrine is particularly relevant in cases involving overlapping subject between the state and central legislation, so ensuring that the beneficial legislation is not stifled due to technicalities. So technical overlaps, indirect encroachment, and on all and technical grounds, the laws cannot be held to be invalid, because the courts will see the beneficial interests on which the particular law has been passed should not be hampered, affected just because there are technical defects. So I hope that you understood the doctrine and this video was helpful for you. If you like the video, please subscribe the channel. Thank you so much.